Good afternoon, everybody. We're going to go ahead and get started here. Thank you so much for joining us today on the real cost of internal teams versus managed HIPAA compliance. We are recording today, and we will be sharing the recording around. So anybody who joins us late, we'll be getting that recording also. So let's go ahead and kick this off. If we're lucky, maybe we can get a couple minutes at the end. I guess it depends on how loquacious I am. He's already starting with SAT words here. So I do want to welcome everybody for attending today. Thank you so much. We're excited to continue to assist you on your path to HIPAA compliance. For those of you who are new to us, we have been in the HIPAA compliance space for over 20 years now. So if you have any questions for us or need any help with your HIPAA compliance, please feel free to reach out to us. I do have Jillian here, who's fantastic. She will be answering any questions, so please make sure you submit those in the chat as we go along. She may interrupt me as we move forward. We will try to get to as many questions as possible at the end of the webinar, and if we can't get to all the questions, because we have such an amazing outpouring of questions around HIPAA compliance, we will share it. We will answer you via email later. So a little bit of housekeeping here, a little bit of disclaimer here. This program is educational, does not constitute, may not be construed as tax or legal advice. The materials here that we're going to reference are subject to change and do so frequently. So please make sure if you have any questions around this that you double check your sources and or reach out to us because we are constantly updating this and reviewing the information that we get from OCR and that we see out there in the wild world of HIPAA, including best business practices. So with that, this is who I am. As you can see, that was from a few years ago when I had longer hair, but still the same person. I'm the Chief Compliance Officer here at Total HIPAA and have been here for over 12 years now. And I do take a personal approach to assisting all of our clients and helping folks who hopefully will become clients with their HIPAA compliance questions and issues that they run into along the way. So let's get started. What is HIPAA? This is the Health Insurance Portability and Accountability Act. This first went into effect in 1996, has gone through many iterations, the most recent being in 2013, which is our omnibus ruling. That's what we're currently working on. I know there's been lots of threats and rumblings about updates, but currently we're still working off the 2013 law. And we do have some updates from the National Institute of Standards and Technology, which you may hear me reference periodically. That is also known as the NIST, N-I-S-T. And the 800-66 is the HIPAA compliance protocols. If you're looking for some good materials for insomnia and you want to work on your sleep hygiene, that's something great that you can go read. Better than Ambien, I can tell you from experience. Who must comply with HIPAA? There are three big groups. There are covered entities. This includes hospitals, clinics, doctors, pharmacies, health insurance providers, and also our covered entities would be our employer health plans. So for folks who have a sponsor, these are self-funded and level funded, and also FSA. Flexible spending accounts are considered HIPAA products, and if your company is providing those products, you are considered a covered entity under the law. Our next step down is our business associates. Those are our third parties that provide IT services, law services, managed service providers, so like our IT providers, looking at billing companies and cloud platforms that have access to the EPHI. And then underneath those, what you'll see is actually directly replicated, but those are business associate subcontractors. Those are folks that serve business associates. So just a little bit, because sometimes this comes up, Covered entities do not have business associate subcontractors. They only have business associates. It's the business associates that have the subcontractors. So if you're contracting with an IT professional and they're providing something like Google Apps or Office 365 for your organization, you only need the agreement with your IT company. You don't need the agreement with the third party then at that point. That would be contracted through your IT services. It's important to know that you are still responsible under the common agency provision, which is part of the omnibus ruling, to make sure that your business associates are compliant, which means that they're double checking to make sure those subcontractors are compliant. Anytime there's a breach in those chain, it can work its way up to you if you're a covered entity, and ultimately cause you to have a breach and could put you in front of the Office of Civil Rights, which is the enforcement body for HIPAA, being OCR. So what does it mean to demonstrate compliance to OCR? This includes a couple of key things. These are things that OCR is going to ask you for if you have a breach, which is an annual risk assessment. You need to make sure that this is updated frequently. This is anytime you have a major change in systems, you have a major change in processes, you need to go through and look at that. So let's say now in 2026, you're now enabling AI in your systems. You need to make sure you've done a risk assessment around that. We've actually just released a risk assessment, and we're continuing to refine that for our clients in 2026, looking at AI, how that is used within a company, what you're doing with it, how you're enabling that, who has access, how you're redacting information, making sure we're not using consumer AI that we see on our devices, which would be like Apple Intelligence, Gemini on your Android phones. We were just having a conversation about that this morning. I know, exciting stuff for you folks, but that's what we do. As we talk about that, and we make sure that our clients are compliant, and this is part of that, making sure that we have eyes and ears on what's going on and where information is and where it's being stored and what has access to that. That is one of the first things that OCR will look for. Workforce training records. They typically will ask for the last 2 to 3 years of training records, so it's important that you have that. Now, we're going to get into this, whether you can do this internally or you can do this. It's good to have a third party. You could do all these things internally, but we're going to talk a lot about what that time looks like and the extra burden on your internal staff with that. Moving forward, they're going to look for privacy and security policies and procedures. Those are typically 2 separate documents. That has to do with the way that the law came into effect. 2002 was the privacy law, and then in 2008 we had the American Reinvestment in the High Tech Act, and that's when we started seeing security as a major part of HIPAA, which is really fascinating when you think back in like 2008, 2009. We were really moving towards digital records. It seems like in 2026 we always had digital records. We always had these things, but when you look back, and I know a lot of you folks have been around for a while with this, we saw file rooms that were very important. These days they're going away. We're getting people retiring those and moving everything into the cloud and into a digital format, which is great for accessibility and great for productivity, but does bring up a lot more issues, which is why you need to have that risk assessment so that you know exactly what you're taking on and what you're pushing to your cloud providers or to your EHRs and your other programs that you may be using, CRMs that may have this information. It's fun when we get into acronym land, isn't it? Business associate agreements, or you may have seen that, talking about acronyms, you may have seen that broken down as 2 BAAs. Those are required agreements. Those are, that's not your typically in your service agreement. That is a separate agreement. I get all the time people go, well, we've got this, this security agreement, or we've got an agreement with this company, but if it doesn't have specific business associate language, it is not a proper agreement according to Office of Civil Rights and your state attorney generals, which are 2 of the enforcement bodies for HIPAA. So we need to make sure we have those agreements in place. We at Total HIPAA have our clients renew those every 2 to 3 years. What we find is that, especially with smaller providers, IT providers, not to call anybody out, lawyers, those sorts of things, that they may see those agreements and go, what is this? And they may have signed it 2 to 3 years ago, but forgotten or just blindly signed this. So we like to have those renewed so that it gives you an opportunity to go through, assess what those people are doing and how you're moving forward with that. Disaster recovery, another thing that is required under HIPAA compliance. How are you dealing with backups? How are you making sure you can get back up and running? This is really important in the age of malware. How do you, get yourself back up and running if your system gets infected? This also includes breach plans. You've got to make sure you have a plan on how you're going to. It's not, if you have a breach, it's when you have a breach and how you reach out to your clients to make sure that they're aware of what's going on, and then potentially notifying Office of Civil Rights, OCR, which is a requirement under HIPAA for notification if you have a breach, and then how you're going about that. So that's very important to have in place. And then any IT infrastructure logs. HIPAA does require 6 years. That can be a little bit onerous. We have that discussion all the time. One of the beautiful things of HIPAA, which is kind of like our Constitution, if it were inflexible, our union would have fallen apart. Wouldn't be around for the 250 years it is. So what we need to make sure is that we have a justification why we're only holding maybe a year's worth of logs, that we're, showing that we've done our due diligence and we've done what we can. And that could be something we say is cost prohibitive, or we just don't have the infrastructure for it. So we just need to document what that risk is and why we don't have it. And that's important. And that's where I think, again, having a third party like Total HIPAA to come in and help validate that and help make sure that we have good records around why we've made those decisions makes these audits a lot easier. And I can tell you, going through multiple audits with OCR and going through carrier audits and looking at what these people are asking for, it's not always hard and fast rules. It's justifying why you made the decisions that you made. All right. So what are some of the top violations that we see? Now, this is a way overgeneralization of it, but the number one in about 80% of what we're seeing today is impermissible use or disclosures. This includes malware. We're seeing a lot of malware attacks. Unfortunately, there are bots out there that are coming at us. They're bombarding us, and we are trying our best to lock everything down. That's where it helps to have, again, the third party who can sit there and say, all right, we need to make sure we have an anti-malware. We've got firewalls configured to only to whitelist items. So we're making sure we're verifying where we want our data to go instead of trying to blacklist everybody. It's a little bit of vernacular there for you. We are looking really to say, how can we lock down our systems as best we can to make sure that that a bot just hits us and moves on. We're getting hit all the time. Our websites get hit constantly. If you have a firewall on your marketing website, it's amazing what you see from all over the world. You can geofence, which basically means you're blocking off certain countries. We work internationally, so it doesn't make sense for us. But those are the kinds of discussions that you want to have with a third party, because it may be that, hey, you only work within the state of Maryland. So you would just want to block everything, all traffic everywhere else. But you say, you know what? We could have somebody come in from Virginia or one of the surrounding states. So let's go ahead and open that up. Or maybe we just open it up to the 50 states and we say, let's keep it just to the 50 states. Or it may make sense to leave that open or shut off certain countries. So those are discussions and things you want to think about. But that impermissible use and disclosure is really what we're seeing most of these days. Next would be a lack of safeguards. Those are typically administrative safeguards. Again, that's doing that risk assessment, you see risk analysis, risk assessment used interchangeably. For our purposes, we've simplified that by saying risk assessments are what you do beforehand, and a risk analysis is what you do after the fact of a breach or an incident that may, even if you have an incident, we should then trigger that risk analysis. Again, that's a reason why you would come to a company like Total HIPAA to help you with this is we are there to help back you up if there is an incident that happens, so we can determine whether that needs to be reported, whether it reaches that threshold of being a breach. With the omnibus ruling, we have to prove that there wasn't harm, so we have to go ahead and assume that everything is a breach before we move forward. So we want to make sure that we're moving in a informed manner, and that's where doing those risk analysis after the fact to make sure that we understand what happened and what information was potentially released. So what we see in that is and we'll be talking a lot about this, is where are those core policies and procedures? Where is that plan, that breach plan? Where is your disaster recovery plan? Those are the kinds of structural and lack of safeguards that HHS is going to fine people for not having. Those are the things they're going to look for after an impermissible use or disclosure. So that sort of opens up that next tier of, okay, we've got more coming at us because, hey, we're now open to an audit. It's like an IRS audit. Once they see you've got one issue, they may look into other issues. It just opens that door. So what we want to do is keep that door closed as long as possible. So that means, having that robust plan. Now, again, these are things you can do internally. I mean, we can all do these things. We understand what they are. The question is whether we do them ourselves. And that's where I think having a third party, having a vendor come in and help to move that forward is really helpful. We were discussing that this morning within our group, and it's kind of like having a cleaning service. We can all clean our houses. We can all, but we know what it takes to make sure that we have a clean house every week. But is that always the best use of our time? And sometimes it's better to have somebody come in because cleaning sometimes falls by the wayside and you go, crap, it's been a week and a half and I really need to get on this. And having a third party just make sure that that's happening with regularity, that those tasks are continuing to be done. The third is we've seen a lot of, and this is a big enforcement. This was big with the first Trump administration, and it's big again, which is patient right and access failures. This means if somebody comes and they ask for their records, that you're releasing those records within a timely manner. You have 15 days at this point to release that information, or you need to give a good reason as to why you're not releasing that information. Failure to pay bills is not a good reason. Court cases could potentially be a reason, but make sure that you're releasing that information to those patients and to those clients as needed and as requested within a timely manner. So we're seeing a lot of fines around that, and those fines, we can help with a lot of lack of safeguards and impermissible use issues, but that right there, that is something that really falls on the client to make sure that they're moving forward with that and that they're getting the proper releases and getting that information to the patients. So give me one sec. So here's a list, and we're seeing the updates, and these are adjusted for inflation. So you can see this isn't your clean numbers that we've seen in the past for, no knowledge, reasonable cause, willful neglect, but an uncorrected neglect. But you see what these 2026 penalties look like. We're seeing what's happening here as we move forward with this. So these are penalties for companies, for organizations. These are not individual penalties. The individual penalties, we still have those criminal penalties that are in place. As far as I know, those are not adjusted on the fines and the fees, but we're really talking about corporate compliance at this point. So these are your monetary, this is what we're looking at today. So this is what 2026 looks like, and we expect in either 2027 or 2028 this to be updated, and we should look for what inflation, these inflation changes will look like. So we've been talking arbitrarily about HIPAA and fines and what this looks like. And I wanted to bring this up because this is really interesting this year. We've had 2 fines this year that have come out in the first part, and it's weird to say this is the first part, but the first half of 2026 have been health plans. We've seen a lot with hospitals in the past. We've seen a lot with business associates. We've seen it on the medical side more than we've seen it on the employer groups and the health plan side. We've seen some Anthem breaches and those big groups, but this is a health plan, guys. And a $245,000 fine was a huge fine to see on this. We have more information around this on our website. We're trying to keep, I could name names, but you can Google this. It's on the HHS if you just do Wall of Shame, if you want to look this up. But the important thing is, as you see, we talked about impermissible releases. This organization fell victim to a ransomware attack. And then they had the core issue was they didn't do a risk assessment beforehand. They didn't have the policies and procedures. They didn't have the training in place. So it was a whole slew of things that just tumbled. And all of a sudden you're looking at a $245,000 fine. So this is why having a partner who can help drive this forward, who's making sure that training is happening, that you're already, that your resources that you have internally, which are already taxed, we're all, trying to find the most affordable and the leanest way to do this. And this is where partnering with a third party like Total HIPAA can really help make sure that this doesn't happen to an organization like yours. And I thought this was a really interesting quote here from the new director at OCR, Paula Standard, saying proactively implementing HIPAA security rule before breach. And that's really important, before a breach or an OCR investigation is not only the law, but is also a regulated entity's best opportunity to prevent, mitigate the harmful effects of a successful cyber attack. So these are things you want to do beforehand. What we want to do, again, we want to make this, we're not going to stop if a state attacker wants in on your site. What we want is the bot to come hit your site and move on. It looks at it, says, if it's coming for a WordPress site, that you've disabled the admin credentials. So that anytime somebody tries to log in with an admin credential, which is a very standard attack on a WordPress, that your site automatically goes, nope, no entry. That is right there. That's a bot attack, and we know it's a bot attack, and we're going to block it right away. And that just, those are simple things that you can do along the way. And what we're trying to do is just make sure that the bot moves on. We can't necessarily stop these attacks from happening. What we can do is just make sure that they just move on. So the operational weight of going internal. Now, this is really, I think, the important conversation to have. And we've been having this is you've got your, if you've got a health plan, you're depending on HR to not only administer the plan, but also to do the training and the compliance and making sure that they've got the policies and procedures in place. Theoretically, working with your IT, which is overtaxed as it is, trying to maintain, trying to keep devices up and running, dealing with malware, dealing with phishing attacks, all these things that are coming at it, having to update things, trying to find budgets, trying to document what they can. It's this too many hats dilemma. If you're relying on folks who do not have an expertise in HIPAA, they may have come across it occasionally or have some limited knowledge of what's going on. Then you're looking at potential burnout. You're looking at people learning about HIPAA on your dime instead of just saying, let me approve this, or learning from a vendor like a Total HIPAA. And you end up with a lot of lag. You end up with a lot of blind spots, and you end up with delayed responses. This is really important to think about is, again, these are things we all could do, but should we do it? That's the conversation. We can if we have the time. We can with unlimited resources. But, in the world that we live in, that doesn't always happen. That's not always available to us. So I say to folks, we hire these third parties. We hire contractors ourselves to help us with things, because there are things that we all know what we can do, but it's better to bring somebody else in to say, you know what, you can help drive that for me. You can help bring that in. Now, you could hire somebody to bring this in and take this internally. But again, is that going to be worth it? Because you're dealing with potential base salaries, you're dealing with any additional compensation that's going on there. You've got software tools they're going to have to bring in. There's continuing education, operational overhead. I mean, all these things about your costs of doing this in-house. This is great if you're a multi-million-dollar company, you've got a compliance department, and even in that situation, your compliance department may be up on other compliance items, might know about SOC 2, might know about ISO 27001 and 002, may know about what needs to happen in that realm, but may not have a full knowledge or full comprehension of HIPAA. HIPAA's got its own little idiosyncrasies, got its own little things that go on. People think they understand the ins and outs of HIPAA because they've read, they've gone to a doctor's office and they say, oh, it's this or it's that. And it's the subtleties is what makes HIPAA. HIPAA is about making sure there's a free flow of information where it needs to be free flowing, but restricted where it's not supposed to be restricted. So managed services like a total HIPAA really give you predictable costs. You've got enterprise level frameworks, continuous training. You've got groups that spend their time on a Wednesday morning looking at the ins and outs of what's going on policy wise, what's happening on a state level. Incredibly interesting conversations we had this morning. We were talking about shield laws in at different states, so making sure that we were informed and that our clients were informed as to what's going on. We're constantly looking at updates. Do you have the resources? Does your team have the resources to keep up to date on what's happening on a daily basis with cyber attacks, with updates, with best business practices, with what's adjustments that are happening that we're seeing from corrective actions from OCR, which is where we get a lot of our information. HIPAA being a legislated item, and we're not seeing a lot of legislation happening at this point, we don't expect that there's going to be an update to HIPAA anytime soon. But what we do see is that OCR gives us corrective actions. We see things from the NIST 866. We see things from these auditors that inform us, hey, we need to make sure that we're updating this. We need to make sure we're on top of this sort of thing. This is where we get items like, let's update our business associate agreements every 2 years. Let's make sure that we're doing annual training because that's one of the requests from OCR auditors. The law just says you should train your employees. Doesn't give you a time frame for that. So we have to look and say, okay, what's the best business practices? So as you can see, this is the difference in those costs. And I think this is why it's so important to make sure that you're working with a third party who, again, can keep those costs down, who understands what's going on and can direct you to make sure you're using your resources in the best places. So we have HIPAA Prime as our flagship program. We handle HIPAA so you don't have to. We're taking care of the dynamic mapping. You've got expert review. You've got my team who has over 15 years of experience to make sure that that we know what's going on, that we understand what's happening with your organization, and then giving you a roadmap to make sure that you know where to put your resources and what's going to be the best bang for your buck. We constantly have these conversations with clients because we are agnostic as to systems that you use. You can use Office 365, you can use SharePoint, you can use ShareFile, you can use Google Apps. We don't care about that. But what we do care about is how are we leveraging what you currently have and making sure that it's being used to its fullest extent. We may recommend a couple of ancillary programs, but really what our job is to use what you have and make sure that we're using it, again, to its fullest extent. So that's where that 30-60-90 roadmap comes in. And making sure that we're guiding you and pushing you in the right directions to making sure that you're being as compliant as possible. So customized plans and training. A lot of folks out there will give you templates. You can go and get templates off the web. The problem is you go in front of an OCR audit and you have templates that do not reflect what you currently do not state what's going on with your current system, and it's just a set of we shall do something. You will fail that audit. that is, they have stated they want to see details. They want to make sure that those are actual written plans. That's something that we do here at Total HIPAA. So I encourage you, as you're going through this process, to make sure that the vendor that you end up using, whether it's us or somebody else, hopefully it's us, that they are actually building and writing a HIPAA compliance plan that reflects what your team is doing. It needs to be built from the ground up, and it needs to reflect your real operational environment. So, really avoid those generic online templates unless you're going to customize those yourselves. A lot of folks come out with really ambitious goals of saying, we're going to do this internally, or we're going to do this ourselves. And then it never happens. That's the long and short of it. And then they come to us to pick up the pieces. And, that's ambitious, and I understand where you're coming from, but really I think that's the part where it helps to have that third party to really help drive that truck, because it is a very large, unwieldy truck, and it can be. So make sure that you've got those business associate agreements and that you're updating those frequently. And then you want to make sure that you're doing role specific training. You want to make sure that you're really pushing forward and you're saying, okay, I'm training my my information security officers and those folks who are making decisions at a certain level, and then the rest of the workforce, and making sure that they're informed as to what they need. The workforce doesn't need to be making administrative decisions. They just need to know how to implement and how to move forward with HIPAA and what currently is happening with your organization. So, and then another item that we tout and that we come up with, that we do here at Total HIPAA, is unlimited breach and defense support. So we have an incident, we're there to back you up. We're there to help you get through this process. As long as you are a client with us and part of the HIPAA Prime program, there are no hourly bills. There is step-by-step mitigation guidance with our experts, and we will show up to any audits that you have, whether it is typically with OCR, they are desk audits, which means we will get a list of questions beforehand. Our clients that have gone through OCR audits send that to us first. We go through it with their team, and we then give their lawyers what we think they need, what we think their internal IT needs to take care of, and then what we need to take care of. And then we come back together. And that process really helps streamline the whole audit process so that we can keep the costs down, so that your lawyer's not trying to create things from scratch, that we become an arm of your team in that defense to make sure that we're moving things forward. It's helpful for that, since we wrote the compliance plan, for the lawyers to have full access to us to make sure that we can go through with that. But also, key to that is there's no additional costs in that annual plan. As long as you're current with us and we continue to move forward and we've created that plan for you, then you get that unlimited audit and breach defense support. So it's really important as you go through this is to understand that you get to reclaim some of that bandwidth. Again, you can do this all yourself. This is all there. There are tools on the OCR site that'll help you go through the risk assessment, that'll give you templates for all these things that you can do. But I caution you that that's hours of work right there. That is potentially 40 to 80 hours of work, especially if you don't know what you're doing. It could double that. That's where we come in to really help take that off your shoulders, and to make sure that you can that you have that reclaimed bandwidth, and that you're just approving things, and it becomes an educational experience not only for your team, but also it is a way to then streamline the entire process. This helps you secure your client trust, and then you have that continuous protection. So one of our favorite quotes here, this is from our director of operations, Tessa Pope, who you guys have probably, most of you, if you are current clients, you know and love. Tessa says this all the time: HIPAA compliance is about the journey, not a destination. So it is constantly evolving. It will constantly evolve. And that's where you need a team that is on top of what's happening and making sure that they're evolving with your compliance plan, continuing to look at things and address things that come up as you go through this. So that was a very quick run through. We did it in about 30 minutes here. I'm going to take just some questions from folks. It looks like we've got a few on hand here, Jillian. So I think this is the part where we call stump the chump. So let's see what people have for me. What you got?
Yeah, we've got a couple questions like determining whether your company is a covered entity or a business associate and what that means in terms of your compliance package and how that changes.
Great. Yeah, great question. Yeah, so there are the three groups as we talked about in the very beginning. And with that, we have so let's start at the top. So we have your covered entities are at the top. Those are your physician practices, that's your healthcare clearing houses, those are your carriers, that's your Anthems, your Blue Cross Blue Shields, your United Healthcares, and your health plan administrators. So that's your self-funded, level funded, and FSA, so flexible savings accounts. Those items fall under, those are covered entities. So those are sort of the top of the rung of the ladder. Those are where information is originating. And they are required to have full compliance. With the omnibus ruling in 2013, actually all tiers are going to have full HIPAA compliance. That requires training, that requires having a full risk assessment, thorough risk assessment, having policies and procedures, having an incident response plan, breach plan, having a disaster recovery plan, and having business associate agreements. All those things are going to be required for all tiers. Next is underneath that. So anybody who serves your covered entities, those are your business associates. Those are your IT professionals. Those are your insurance agents. Those are your lawyers, your accountants, anybody who has access. Third-party administrators, or TPAs as they're known, are also what we would call your business associates. And then your business associate subcontractors fall underneath that. Those are your third parties that support your business associates. So your business associates, I think I used this example earlier, but your IT team contracts with a cloud provider for you. They would then have a business associate subcontractor agreement. Typically they would just say a business associate agreement, but they would be a subcontractor. So you would have the agreement with your IT professional, but not with the cloud provider that they're giving your services for. Again, all three will have to be HIPAA compliant. It's a foregone conclusion. There is, do not collect $200, do not pass go. They all have to go through this process. It sounds onerous, and it can be if you don't have a qualified vendor to help you through that process. But really what it comes down to is you've got to do this. It is required, and if you don't do it, your fines are much higher. So I'm going to go back to that slide about what the fines and the penalties look like, and that would immediately fall into a tier 4 fine. You could get it down to a tier 3 because you've done willful neglect, and you would have to correct it within 30 days of discovery. There might be some wiggle room there if you bring legal counsel in, but we're talking about already starting with a minimum of a $14,000 fine, capped at $2.1 million per violation. We've seen larger fines. That's important to remember that if you have a malware incident that happens, but then they discover you don't have training and you don't have a plan, you don't have documents, those are 3 separate items there, folks. So those each are capped at $2.1 million. So, it's important to remember that it's not just the incident itself. It can be additional items, and that can really open you up to more fines and higher penalties. Okay.
Kind of along those lines, if from British, we have a question about SaaS applications with patient drainage care and if they need to be HIPAA compliant. So it sounds like a business associate potentially.
Yeah. If you're talking, it looks like business associate. I'd have to know a little bit more about the program, but this sounds like, yes, this would be a business associate. Would require that you would need a business associate agreement with them. recommend that you ask to see at least a summary of their HIPAA compliance plan. A lot of these folks will post that on their website under their security section. It's good to get eyes on that, see what they're doing, what they've done with that what they're doing, how they're protecting information. You can put them, we do have a audit. And I think, Jillian, if you could send that over to them, that would be really helpful. That is a little checklist to go through and have them fill out. And it asks, when was the last time they trained folks? Have they done a thorough risk assessment? When was that last done? Any policies and procedures, when those were last reviewed? Do they have a disaster recovery plan, incident plan, and just making sure that that's in place. But on our website, you can download our free business associate agreement that was just recently updated with new information, especially around the substance use and disorder information that just came into effect in February. Again, reasons why you want to be with a good third party who's on top of this. You can download that for free. And that's also, you want to make sure that you have one of those in place. Again, I would make sure that you do that every 2 to 3 years and review that with that vendor to make sure that they are continuing to keep themselves in compliance.
Great.
All right.
Along those lines, what specific audit evidence or documentation is necessary to prove compliance?
Yeah. So, what they're really looking for is they're looking for those training records. That's going to be the first thing. So certificates of completion, that will potentially ask for an outline of what was covered in the training. But we're really looking for when was it completed? When was the last time it was completed? So we want to make sure we have those annual certificates, which is what we provide. You're going to want a thorough risk assessment that says, this is what we looked at the system, this is what we did. That needs to cover 3 key areas. On a high level, that's administrative items. So it's making sure you've appointed a privacy officer, information security officer, that you've gone through and done your documentation reviews. The next will be privacy, which is dealing more with physical paper security, making sure that information, I know a lot of that's going away, but we do have that requirement from keeping records for 6 years, and that those paper records, we may need to keep those unless we've transferred those to digital format. And then technical, which is the heaviest lift of them all. And that's going to go through and look at systems as access control, what you're doing from firewalls, malware, AI, cloud storage, what you allow access to, how you're doing our minimum necessary. So what's the minimum amount of information that somebody needs to perform their job? So they're going to look for that. And when was the last time it was updated? They're going to look for thorough policies and procedures, both privacy and security, and then what your breach incident plan looks like, how you reached out to people, what information you released at that time. That's typically what they're going to look for. Your documentation within your risk assessment, they may ask to see screenshots of, say, your Active Directory to make sure that you do have multi-factor authentication enabled for internal programs. They may ask to see logs around items to make sure that things were properly configured. But typically, if you come with the proper documentation, we've not seen many more questions come beyond that. So the key is to be thorough, which is what having a vendor really helps with, and then making sure that you answer the questions that were asked, and nothing more, nothing less. So
Why couldn't an internal team just use online templates, spreadsheets, whatever's available for free online to create their compliance package?
You could. And I have a business book over there called Scaling Up that I've been looking at for 4 years now. And I've thought I can do all these things, but you know what? It helped to get a vendor in to help unstick me, and unstick what happens with this. We all have grandiose plans of what we want to do and what we need to do, but life gets in the way, and do you have an extra 40 to 80 hours in your in your year to do something like this. I think having a vendor that can help move this forward and cut that down to a 5 to 10 hour review over a period of time, and not at one time, but breaking that down into smaller bite-sized chunks and helping to move it forward and making sure that these things are being done. And it also helps with third-party validation. Jillian is probably going to roll her eyes at me in this second. You can't see her right this second, but my favorite story is the Jurassic Park, the original movie. When the power goes off, all the locks unlocked and all the dinosaurs got out. And there had one person writing all the code for that. And he didn't think at the time when power went out that maybe those locks should stay locked. And that's where you want a third party to look at it and say, hey, I know you've configured everything what you think is proper, but I see a hole here. And that's where that third party comes in, and I think really helps validate that the security posture is what you need it to be, and that it is thorough, and that you're not missing things. And if you are missing things, that we're making informed decisions around it. We're saying, okay, we're going to accept this risk for this year, or we're going to accept this going forward because the cost is going to be prohibitive for us and we're not going to get that much more bang for the buck. But we also see a huge issue, which we can turn on the firewalls internally, or we could start using a VPN. We already have access to that. Or, instead of allowing our agents as they go out on the road to use, open Wi-Fi, we're going to require them to sync up with their phones and through Bluetooth and use so that you've got a private network that way. And that means maybe we need to expand those plans for our agents and those sorts of things. So those are the discussions that you want to have. You could do this all internally. Lots of people have great intentions of doing this. I'm guilty of it myself. But, it goes back to that, just because you can doesn't necessarily mean you should. It's not going to be necessarily the best bang for your buck, and you're going to be stuck in a major crisis if you have a breach versus, having the backup of a group that can do this for you and help move this forward for you. So a long-winded answer to, sure, you could.
I feel like you kind of touched on it, but just to highlight it too, the kind of downsides of doing it internally, and the way that we sit here and we look at HIPAA every day and we look at how it changes. And just this year, in the past few years, we've seen reproductive rights, we've seen the substance use disorder, and there are updates that change, kind of all hidden, and it's legalese. It's not fun to go through.
Yeah. Well, and there are unintended consequences with corrective actions and things that we see within those, that, somebody said this, an auditor writes something, or we see a decision that's made that informs us and says, ooh, we need to look at that. But yeah, I mean, the changes with I think you bring up some really good parts, is the substance use and disorder is a major update to HIPAA and the fines that are there and the enforcement that's going around that. And that's going to be an enforcement issue that we're going to see going forward. It's going to take a couple of months for this to get ramped up and to see these fines come in, but we expect in the next year or two to start seeing major fines coming out of that for people not keeping that information private. So yes, you can do all these things yourself. You can make sure that, you can do this, but if you are an insurance agent who's out looking for new business and working hard to find new clients, are you also going to sit at home on a Friday or Saturday night when you could be spending time with your partner or with your family researching about HIPAA so that you can implement that on Monday? And that's where I think having that third party, this is what we do. It's like you go to a specialist for, like you go to a specialist lawyer when you need, business, versus you're dealing with a some sort of other litigation. This is why you come to these third parties, because we understand what's going on. We can save you money, we can save you time, and you're not sitting there like just hunting through this haystack of regulations as to what's going to apply to you and what's going to be something that you're going to miss along the way, which could be a huge red flag and open you up to an OCR audit. And our goal is to keep you from actually having the audits in the first place as much as possible.
Great. If no one else has any questions, that's all we've got for you.
Awesome. Well, thank you again, everybody, for coming out. If you have any additional questions for us, please feel free to reach out on our website. That's totalhipaa.com. See, I think I've got it. And you can also schedule a clarity call there with us. If you'd like to learn more about our services, or if you'd like to have a discussion about your specific plan, no obligation. It's a short 15-minute call where we can discuss what's going on and maybe help you out with specific questions that you have, or help you maybe you want to come on board with us and have us look at your overall security stance. Those are things we can help you with. But again, everybody, we really appreciate your coming out here. Thank you so much, and have a wonderful rest of your day.